Thank you very much, and it's an enormous honour to be here to speak about environmental justice. And I suppose to begin by saying that I've been given a very specific brief this afternoon. This isn't an environmental law conference, and the instructions I've been given from Áine and others is to hopefully map out what general lessons might be learned in terms of access to justice from the environmental law experience to date. So it's rather different to what I usually do at environmental law conferences. So I want to talk about what I call a puzzle, and I'll explain in a minute what that puzzle is, and I'm then going to attempt to identify a missing piece of the puzzle and hopefully get you thinking about how we might complete the picture and the challenges that arise in that particular context. But I want to begin by making some general remarks, and the first is to go back to some references we already had earlier this morning about environmental law perhaps providing the so-called gold standard in terms of access to justice. And I just want to pause for a minute and unpick what it is that we mean when we talk about the gold standard. Certainly environmental law, when you look at the international dimension and the European Union dimension, there's no doubt environmental law sets what I call a benchmark or a set of minimum standards that must be met in the specific context of access to justice in environmental matters. But they are more explicit, I suppose, than what you tend to see in general rules governing access to justice. They set out more clearly what specifically is required, and those details are important, there's no doubt about that. But, and this is an important but, the challenge, as ever, is in implementing that so-called gold standard, because without the resources and without the political will, the gold standard, as every other standard, will remain aspirational. So again, be cautious about what you wish for in terms of a gold standard. But what I want to look at to begin with is where we can find the environmental standard, so to speak. And we start with the international dimension and an international treaty called the Aarhus Convention. This treaty has been ratified by 47 state parties, including Ireland, including all of the EU member states, and including the European Union itself. That's very significant, and I'll explain why in a moment. But one core element of the Aarhus Convention is that it guarantees a right of access to a review procedure that is not prohibitively expensive. Very simple, very elegant, deceptively so. You have a right of access to justice that's not prohibitively expensive. The Convention doesn't leave matters there. It goes on to talk about the review procedure also having to be fair, equitable, and it's interesting that both terms are found in the Convention. It must be fair and equitable. It must also be timely. It must provide adequate and effective remedies, and it must, of course, provide injunctive relief as appropriate. So that, in effect, is the basics of what the Aarhus Convention sets out as regards the right of access to justice in environmental matters. But if you think about it, there's nothing particularly new or dramatic there, and this is the so-called gold standard. It simply spells out the detail, more specifically, perhaps, than other instruments do. But there is nothing particularly dramatic here. You could say that these are fundamentals of the rule of law, and that anybody who seeks to enforce any right, whether it's environmental or not, should of course have access to a review procedure that's affordable, timely, provides adequate and effective remedies, and that injunctive relief is available where that is appropriate. So really what the Aarhus Convention offers by giving this element of explicit detail is perhaps a right of access to justice that has a sharper edge, that's more visible in terms of what states must deliver. And because it's more visible and more explicit, it's arguably more enforceable. Judges, as we know, tend to like specifics, and when you talk in general terms, that can be difficult to get traction. But here there is a specific, explicit legal right to affordable access to justice with these particular characteristics. The Convention then, of course, is very practical, and it says very sensible things, and these are all written into the Convention text, so they're technically binding law. States must provide information to people about the right of access to justice in environmental matters. In other words, putting it very simply, there's no point having the right of access to justice unless you know that you have that right, and unless the state explains to you how you can go about giving effect to that particular right. It's stating the obvious, but sometimes it's important to state the obvious, because people day in, day out are simply unaware of their rights, and I find that quite a lot in the environmental context. The Convention also speaks specifically about parties. Those are the state parties, Ireland being amongst them, also the European Union. The Convention says states such as Ireland shall consider, that's the language used, so they must consider the establishment of what the Convention calls appropriate assistance mechanisms to remove or reduce financial and other barriers to access to justice. So there's an express reference to financial barriers, other barriers as well, which remain unspecified, but it's clear what they might be. But the key point here is nowhere in the Convention is there any explicit reference to legal aid. It doesn't appear expressly. This is the closest the Convention comes to potentially nodding towards some form of financial assistance. But the message is clear. The financial barrier, if there is one, must be eliminated. The Convention then tells us there's no problem with national courts awarding what it describes as reasonable costs in judicial proceedings. So again, that's an important baseline. There's nothing in international law to prevent national courts making an order for reasonable costs. And of course, reasonable isn't defined, so that's another issue. What is reasonable in practical terms? And that, of course, will vary from case to case, depending on the circumstances. The Convention, in a rather obtuse reference, then makes an explicit reference to the idea of giving the public wide access to justice. And if you look at the Convention text, this express reference to wide access to justice, which again isn't defined, arises specifically in the context of locus standi. But interestingly, in the jurisprudence, including the jurisprudence of the Court of Justice of the European Union, the court has latched on to this idea of wide access to justice to also push forward the idea of affordable access to justice. But again, how wide is wide access to justice? How far does the law expect us to go? Those questions are quite fuzzy at the edges. Final point about the Convention, it has always given a very special or prized position to environmental NGOs who are set up, whether you agree or not, as the champions who will stand up in the public interest to defend the environment. And that is the view that the Convention takes, and it's a very strong position, and we see that also has been picked up by the Court of Justice of the European Union. Going back then to the basic point, this right of access to justice that's not prohibitively expensive, what can we say then? What has been said so far in terms of interpreting this particular provision? How do you measure in a particular case whether or not access to justice is prohibitively expensive or not? Has the standard been met in a particular state system? And it's probably predictable to say the first port of call must be the jurisprudence of the body that's tasked with enforcing the Aarhus Convention, and that would of course be the Aarhus Convention Compliance Committee, which sits in Geneva. That compliance committee comprises 9 members, all of which are lawyers. I was appointed to this committee in 2015. I've been its vice chair since 2017. I speak here in a personal capacity. But we are sent communications or complaints, usually from individuals or NGOs, and they ask us to consider whether state parties, including, for example, the European Union, the UK, Ireland, whoever it might be, we have 47 state parties, whether state parties are compliant with their international environmental law obligations. And again, it is our practice usually to hold oral hearings in these cases to tease out the various issues that arise. And we have held hearings and we have made findings as regards the concept of access to justice that is not prohibitively expensive. This is where we sit in Geneva. It's all quite a formal arrangement. And again, although we're not a court, we make findings and recommendations in respect to particular state parties. What the Compliance Committee has had to say so far in very general terms about the not prohibitively expensive requirement can be summarised in a few overview points, I put it like that. There's a lot of detail here, but these are, I suppose, the key messages. The Compliance Committee is very conscious that there is an enormous public interest in environmental protection and that it is absolutely vital that environmental law is enforced in practice. And again, the Convention sees the role of NGOs as being vitally important there, and the Compliance Committee is keen to ensure that NGOs have an effective right of access to the courts. When we have to consider whether a particular state party is compliant with the Convention or not, we look, as you might expect, not at specific aspects of the national legal system, but at the national cost system as a whole. For example, you might well have a loser pays system, but you might also compensate for that by having protective costs rules, for example, some kind of cost capping system, or some combination of all of those with some form of legal aid or other financial assistance mechanism. Again, under the Convention, predictably, state parties have quite a degree of discretion or flexibility as regards how they actually deliver affordable access to justice. So the Convention isn't particularly prescriptive. There is room for manoeuvre there, but you have to meet the minimum standard. There must be affordable access to justice. So we have to look at the overall picture within each particular state party. But what we do insist on, and again this is basic, but you would be surprised how much it gets lost in translation sometimes, the national system must have a clear rule, and that will usually be in the form of legislation. A clear rule that prevents prohibitively expensive costs in the context of environmental litigation. So clarity and predictability, so that litigants know where they stand in advance, is a crucially important part of all of this. And again, we are very much committed to equality of arms between the parties to litigation, and that takes on a very specific meaning in the context of environmental litigation, where in many cases you might have a very poorly resourced individual going up against the state and or a very well-resourced developer. So again, that's very much modelled on the model that comes from the European Convention system, but it's an important point that needs to be kept in mind. Also, again, some of this is so basic, but it's often forgotten. You must consider the costs that a claimant, the litigant, has to bear in their entirety, starting with court fees or stamp duty, lawyers' costs, additional fees that it might take to appeal, for example. So again, all of the costs are put into the mix. And it's important as well that is the position, and that's how, whether something is prohibitively expensive or not, is ultimately measured or calculated. Now, the Compliance Committee in its jurisprudence has said a lot about access to environmental justice. This is just a taster, if you like, but these are the core baseline points, if I can put it like that. But I want to move now to look to see something that might be arguably more relevant because it comes closer, I suppose, to the domestic legal system. Aarhus is international law, and the interaction between international law and the Irish legal system is quite complicated. Again, I don't intend to get into that in this particular forum, but what I do want to talk about is the so-called Europeanisation of the Aarhus Convention. Putting this very simply, the Aarhus Convention is part and parcel of the European Union legal order. It is part of European Union law, and therefore part of Irish law, and therefore has that sharp edge that David Fennelly mentioned and can be relied on and enforced, in theory at least, before the Irish courts. As well as the Aarhus Convention in and of itself, and the details that I've mentioned a while ago, we also have specific European Union legislation in the form of European Union directives, one on the right of access to environmental information and another on the right to participate in environmental decision making. And both of those directives include an explicit right of access to justice to enforce your environmental rights. So there is quite a substantial body of law there that's quite complex and needs a lot of teasing out. But what I'd like to focus on for today's purposes is the jurisprudence of the Court of Justice and what the Court of Justice has had to say so far, because this is an ongoing story, constantly in motion and very difficult to pin down. But what has the Court of Justice had to say as regards the not prohibitively expensive obligation? And it's interesting when you compare what the Compliance Committee has said so far on this topic with what the Court of Justice has said, there's a very strong degree of overlap. even though the Compliance Committee doesn't in any manner means follow what the Court of Justice says. We take note, and we're aware, of course, of what's happening in Luxembourg. But we oversee 47 state parties. We don't just oversee member states of the European Union. So it would be wrong and bring us into even more disrepute if we were to apply the EU standard to countries that are not part and parcel of the European Union. But again, the Court of Justice, of course, is incredibly influential. And insofar as Irish law is concerned, and Irish environmental law, of course, the Court of Justice jurisprudence is binding. So it's interesting that to date there have been 5 judgments from the Court of Justice specifically dealing with the net point regarding what is not prohibitively expensive. And the common denominator in those 5, of course, is that they involve Ireland and the United Kingdom, the 2 main common law jurisdictions, where again, as the Chief Justice explained this morning, the state passes, if you like, the burden of carrying the litigation to the parties. So it's not a huge surprise to find that the costs in Ireland and the UK are the big issues in terms of the Aarhus Convention. In other jurisdictions, for example, Germany and Austria, they've had difficulty and continue to have difficulty with standing requirements, specifically for environmental NGOs. So again, as David said, different jurisdictions have different issues as regards compliance with the Aarhus Convention, depending on their legal tradition and the way they have, over time, organised their legal structures. But again, just looking here, Edwards was a reference for a preliminary ruling from the UK Supreme Court, North East Pylon is a reference from the Irish High Court, and Clone a reference from the Irish Supreme Court. So it's clear that the Irish jurisprudence has played quite a significant role in enabling the Court of Justice to tease out or to explain the meaning of this ban on prohibitive costs. And the difficulty, I suppose, with Court of Justice jurisprudence is when they rule not just for Ireland or for the United Kingdom, but for the 28 member states. And they tend to rule in rather general terms. And sometimes you could be left quite frustrated where they don't give the specifics. You'd like to know more. Can you give us a number? Would it be 5,000, 10,000, 15,000? That would be prohibitively expensive. But they won't do that, and I don't think they ever will. They tend to talk in more general terms, because again, they are directing their rulings to 28 member states. But taking the jurisprudence to date, which is these particular cases, what comes out very clearly in terms of the hallmarks that you see time and time again in the Court of Justice jurisprudence is the emphasis they put again, just like the Compliance Committee, on the public interest in environmental protection, the vital role that environmental NGOs play, and the fundamental principle of effective judicial protection. If European Union law gives you rights, they must be protected, and you must be able to turn to a court to actually deliver those rights for you in practical terms. And again, it's what I said at the start about the so-called gold standard. Before there was ever an Aarhus Convention, the Court of Justice was firmly wedded to the idea of effective judicial protection. And if you unpack that particular concept, surely at its heart has to be affordable, timely and effective access to justice. So really in terms of added value, what the Aarhus Convention has brought to this particular debate is some specifics. Again, it has spelled out the content of effective judicial protection. But there's nothing particularly new or dramatic there. Timely, adequate, effective and affordable. So again, there is clear potential for the so-called Aarhus gold standard to spill over into other areas of law. And I believe we're beginning to see signs of that happening already. But what has come out very much from the so-called Europeanisation of the Convention and the Court of Justice jurisprudence, and again I'm putting this in very simple and very brief terms because this is a long and sordid story that has dragged on for many years about how to give effect to the Aarhus Convention in the member states. One very strong theme is the last point here, where the Court of Justice has said time and time again that if there's a gap in the national legal system, if national legislation or national procedure rules don't provide for the ban on prohibitively expensive costs, well then the obligation falls firmly on the national courts, because they are EU courts, to step up and fill in that gap. and that will usually involve interpreting national law in compliance with European Union law to make sure that the net result in the particular case is that somebody is not burdened with prohibitively expensive costs. So there is a very, very strong interpretive obligation, which again has been confirmed in very clear terms in the most recent jurisprudence, 2 Irish cases as it turned out, North East Pyland and then more recently the Clone judgment. Now there are a lot of other things that you could say about the North East Pyland judgment in particular. Other people have made comments about those in other fora. I won't get into that here, but that's not to say that I don't have views on these particular cases. But one of the advantages of speaking at a forum like this is that I can try to just keep things at a general level. Moving then to Ireland, initially the reception that the Aarhus Convention got here wasn't particularly positive. And again, the general feeling was our system of judicial review is first rate, we don't need to do anything. We have a very capable system of judicial review, capable of protecting people's rights, and there's no need for us to amend our cost rules or do anything else to comply with this particular plank of the Aarhus Convention. And there was even one High Court case in 2007, Cavan, Ireland, where Mr. Justice T.C. Smith described the convention as being a cranks charter, and that there would be a free-for-all if the unsuccessful litigant could somehow escape liability for their opponent's costs. And that wording, the cranks charter, I think in 2007 stands out as a testament to how much things have changed in the interim period. What Ireland has done in very, very simple terms in response to the Aarhus environmental law obligation as regards the ban on prohibitive expense is we have put in place a so-called special costs regime that applies to certain categories of environmental litigation. And again, the general principle here is that the loser pays rule, the usual rule, is put to one side. And there's certainly no doubt that the special cost rule has improved things. Again, some would argue that there is a degree of uncertainty that remains, that there are gaps, that more needs to be done, but certainly things are better now than they used to be prior to the introduction of these special cost rules. And we have certainly seen the Europeanisation of the Aarhus rights within the Irish legal system. But we are certainly, it's fair to say, in a situation right now where these rules are still being bedded down, notwithstanding that the ban on prohibitive costs has been in place in Aarhus terms since 1998 and in European Union law terms since 2005. So it has taken a very, very long time for the jurisprudence to tease out what precisely not prohibitively expensive means, and that story is still being played out. The current state of play comes back to the sleeping giant that was mentioned earlier. What's going to be the next step? And that is to some extent the missing piece of the puzzle. How far do state parties have to go to actually ultimately deliver access to justice that is affordable and effective? So in terms of what lies ahead, it is important, I think, to mention Conway in Ireland, which is a Supreme Court decision from 2017. This is a judgment of Clark J, as he then was, where in an arbiter, a very important arbiter observation, Mr. Justice Clark did flag the possibility of a right to legal aid or some form of financial assistance, because again, that's the language of the Aarhus Convention. Aarhus doesn't explicitly say anything about legal aid, it's more nuanced. That perhaps in certain circumstances a right to legal aid or some equivalent may well arise. But he did indeed flag that there were important and difficult issues that remain to be teased out there. So again, watch that space in terms of what might happen next. And the Conway judgment drew very specifically on the Edwards judgment from the European Court of Justice, where again the court gave some helpful, not conclusive, but some helpful guidance as to what not prohibitively expensive means in practical terms. Interesting too in Conway in Ireland that the Supreme Court confirmed that it was appropriate within the Irish legal system for the Irish courts to have regard to the findings of the Compliance Committee. So again, what the Compliance Committee has to say about the Aarhus obligations is of relevance in terms of developments in Irish law, and the Conway judgement also confirms that it is appropriate to look to a very important document, the Aarhus Convention Implementation Guide, which again sets out more detail as to what the specific Aarhus rights might involve in terms of giving effect to them in practice. So then, to attempt a conclusion, I want to also mention environmental law more generally, what I call environmental law in the balance, because it isn't all just about costs, and it isn't all just about affordable access to justice. There is quite a number of significant environmental cases making their way to the Supreme Court now because of the new constitutional architecture whereby you can get the so-called leapfrog appeal. And that has perhaps been an unforeseen consequence of the constitutional amendment, but that is in effect what is happening. Very many now environmental cases are making it to the Supreme Court. And I just want to flag the Grace and Sweetman case, because this is a hugely important case about locus standi, because it's important before you get to costs at all. If people can't get in the door of the court, you're cut off at the legs, so to speak. And again, this comes back to the enormous public interest in environmental protection. Grace and Sweetman, many of you might be aware, concerned the proposed development of a 16-turbine wind farm in a site protected under European Union law. And again, the specific species at issue here was, of course, the hen harrier. And it's significant that the Supreme Court took a fairly broad approach to standing and made the very clear point, echoing, I think, the trend in the European Court of Justice, that the protection of these sites, these protected sites under the Birds and Habitats Directive, involves the legitimate interests of arguably every citizen. The legitimate interests of arguably every citizen, which then justified, as the Supreme Court saw it, a liberal approach to standing, which is a good thing. And again, one would hope to see that environmental law and environmental protection and enforcement of environmental law being an important theme in the forthcoming Supreme Court jurisprudence. So then, to conclude, in terms of the so-called gold standard, this is what we've got. Under the Aarhus Convention and European Union law, the cost of environmental litigation must not be so expensive that it prevents the public, individuals and NGOs, from bringing a challenge which would normally involve judicial review or enforcing national environmental law. In environmental terms, a lot of the emphasis is on judicial review, challenging on board Planola, challenging the EPA and so forth. But there is another enormous dimension that is often pushed to one side, and that is so-called citizen enforcement and the role of public authorities in stepping up to enforce environmental law when there is a clear breach. And the kinds of scenarios I'm talking about here are obvious, and it's disappointing that they're often ignored. Illegal dumping is one, illegal hedge cutting is another, the unauthorised demolition of protected sites, and another, what I see as being a growth area, air pollution. Moving into the future, there's absolutely no doubt in my mind that air pollution is going to become a particularly hot topic.